constrained in this matter to take two drastic steps. One, to drag the trial magistrate here. I don't know whether she's even still a trial magistrate, to the Judicial Service Commission on grounds of incompetence and demonstration of bias in the matter and failure to impartially dispense justice. The other step we have also taken is to ask her to recuse herself from this particular matter because of apparent bias and incompetence. She has indicated she is going to deliver a ruling on the 26th day of this month. So hopefully she will take the right decision, because this is a serious matter which touches the lives of our clients. It's a matter which is extremely delicate. It's a grave offense which invites a sentence of death in the case of conviction. So that's how serious it is, and we don't want anything to be, handled in a manner which is not satisfactory. That's why we cannot leave any stone unturned in pursuit of justice for our clients. So this is the full length we have to go, and we are ready for a long haul in this matter, because it would appear this court now is becoming another kangaroo tribunal, like the General Court Martial, where Dr. Besigye and Obedi Lutale were arraigned before. You remember how we labored, how we struggled, how we waged a protracted battle to get out of the General Court Martial to come to civilian courts, where we thought at least there is some breath of fresh air, that there would be justice, that there will be respect to the dictates of the Constitution. But Allah, she's turning out to be like Franco Mugabe. This magistrate is becoming another Franco Mugabe, the one of General Court Martial. Flagrantly disregarding mandatory provisions of the Constitution, like Article 23, which talks about mandatory bail after one has clocked 180 days on remand. It's couched in mandatory terms, including the Magistrates Court Act, Section 76, which dictates that once one has spent more than 180 days on remand, no any other business you are going to conduct, save for considering the application for mandatory bail. As we speak today, she has even failed, dismally failed, to pronounce herself on just a simple matter of computing time, computing the period the accused persons have been on remand. Let alone doing a simple thing which is provided for in Regulation 10 or Guideline 10 of the practice guidelines that were given by the Chief Justice, that in the event that the trial magistrate who is conducting the pre-trial processes in a capital offense like this one find themselves in a situation where they have one accused who has spent more than 180 days on remand before committal, you forward the file to High Court. We ask for just a simple thing, that kindly submit the file to High Court for purposes of processing mandatory bail for Dr. Besigye and Obedi, and she declined in total disregard or blatant disregard of the express provisions of the Constitution. So this is gross incompetence. The other thing is about legal representation. I think all the issues, as you heard here, we have succinctly raised them, that a matter of this nature, which invites a death sentence or capital offenses like this one, you cannot in any way proceed with an accused unrepresented. Actually, the law dictates that is the Constitution. In the event that an accused person does not have a private lawyer, the state is duty-bound to provide one at their expense, and rather actually at the expense of the state. That's how serious the Constitution is. So it's on record. On the day of committal here, the council who are here were really not satisfied with the conduct of the matter, and they withdrew from the bar. So, subsequent to the withdrawal of counsel from the bar, what the magistrate ought to have done within the parameters of the law was either to adjourn the matter to allow the accused persons get another lawyer, or get one for them at the expense of the state. But she did the unthinkable in unobdurate disregard of the dictates of the Constitution. Said, you opted to waive your right for legal representation. It was an absurdity, a travesty. So, she proceeded to commit the accused persons without legal representation. That is a terrible, terrible violation of the judicial oath. How can you do that? A magistrate who is addressing yourself and your mind to the law, you can take such outrageous decision. The final one is about disapplication. It's outrageous. I am telling you this. This is a case in a class of its own. It has never happened. It has not happened anywhere in our jurisprudence, in our criminal justice system, that you commit accused persons to high court for trial, and then you open up the matter for an interlocutor application to allow the state to continue with the investigations. The import of committal proceedings that the state is done with investigations. That's why actually the Constitution gives them the latitude of using like 6 months, 180 days within which to conduct investigations. And the reason they are pre-trial processes conducted before magistrates in a matter which is triable by the High Court, that the High Court is saved the burden of going into issues to do with the investigations, managing the pre-trial processes, and what they say, okay, those pre-trial processes, let them be handled by magistrates' courts. Once the file is well assembled and ready for trial, forward it to High Court. And that's what the state did the last time we appeared here. They indicated they were done with the investigations, they had summed up their case, they had assembled the necessary evidence, and they were good to go. They were set to proceed with the hearing. Now, this application, which was coming up today, is seeking to reopen up again investigations to allow the state to access data on Besigye's phones and Obed Lutare's phones. Can you imagine? So, one would ask, and for heaven's sake, I shouldn't even be asking this question. Once you allow them now to open up the phones and access data, what do they do with whatever evidence they are going to gather after committal? Because you have already made the committal proceedings. You have already forwarded the High Court to, you have already forwarded the file to High Court. It's already before High Court for trial. Now, whatever evidence they are going to gather subsequent to the committal, to what effect? Is for what purpose? So it's just even a matter of logic. You, even non-lawyers, you can even tell that actually what she's doing is irregular. So it's the reason our clients, not we as lawyers, our clients deemed it appropriate to drag the magistrate to the Judicial Service Commission for disciplinary action because of that gross incompetence and abuse of the judicial oath. And also, we are instructed to seek for a recusal, rather to seek a recusal, which we have appropriately done here. That is how the law is coached. Judicial maladministration of justice. You see, it's about failure of the judicial officer to dispense justice in accordance with the law. Yet once they take oath, the judicial oath, it's all about that. We will have to uphold the law, to dispense justice in accordance with the law, which has dismally failed to do. Well, I will start with the way forward. We are just waiting for her decision on the 26th day of this month. because we have made our case, or the case for our client has been made, and I think we have done our best under the circumstances. We have executed our duties. We have indicated to her that after Komito, she has exhausted her mandate. She has no jurisdiction whatsoever. She has no residue powers to conduct any business concerning Dr. Besigye and Obedi Lutale matter. She has no business with Besigye. No business at all. This is what we are telling her. So to purport to come up with that application is abuse of the judicial oath. And now you are asking, yes, was she aware of the complaint we took to the Judicial Service Commission? That much, well, we don't know because we served the court. That was this morning, but we supplied her with another copy. So it's okay. Whether she has convened or not, at least now she knows that there is a matter against her before the Judicial Service Commission, where now the accused persons or the applicants, Dr. Besigye and Obedi Lutale, are taking her on. So now it's a matter, there is a case now before the Judicial Service Commission between Obedi Lutale, Dr. Besigye, and the magistrate herself. So until that is resolved, definitely she cannot proceed.
I just wanted to say that from the non-lawyer perspective, that judicial power is derived from the people of Uganda. And therefore, that must be exercised without bias, without personal interest, without emotions. And therefore, as non-lawyers, when we see somebody who holds judicial power putting in emotions and personal interests, we don't even need to be lawyers to know that such a person should not be in such a position. And so I am happy that the lawyers have applied for her to excuse herself, and that's what it is supposed to be.